We are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system.
Black people are the same thing as disabled people, according to Justice Ketanji Brown Jackson.
No, she might not be saying that. What she's saying is something very much like that.
This is from Janai Nelson again from the NAACP, basically arguing in favor of keeping congressionally black districts that are clearly racially manipulated.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not.
Come on, man. Stop making this so easy. This is like, everybody listen. I know you're like, I did not just hear what I thought I heard. You did. I'm going to play it again. This is pure gold. This was actually being argued by the attorney representing the NAACP in the case, oral arguments to the Supreme Court, that this is why we need them, because even the white Democrats.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Holy shit.
Imagine actually saying, we can't win by votes.
We can't win without this bullshit cheating.
Therefore, do it. Therefore, keep it. It's ridiculous.
And Ketanji Brown Jackson agrees with her. We'll get there. We got some clips. But I mean, listen to this last part that's so, I could not believe this was actually being stated not only out loud by these attorneys, but in actual oral arguments on the record.
Chasm between how black and white voters vote in Louisiana, that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Race is the driving factor for voting. So therefore, we have to keep doing this. She's literally saying that, oh no, this is an issue about race. Absolutely. It is the driving factor, but ignore the Constitution because we need it.
I mean, if I were writing this opinion for the majority, I would feed this right back in. I mean, it's...
When I told y'all earlier in the show that these people, they literally have nowhere else to go, and they are now just outright saying the quiet parts out loud because there is no hiding the bullshit anymore. That right there, what she just said, what Janai Nelson just said, attorney representing the NAACP in front of the Supreme Court, just said, yes, race is the big factor here. It has to be because white people won't vote for black people. Wow. Oh, God. Meanwhile, right. somebody explain real quick, Ron. Somebody in the chat. Y'all going to have to explain people like Byron Dorgan to me then. A black Republican in Florida that's probably going to be the next governor of Florida. And Florida is getting
those people don't count. Obama doesn't count.
Oh, shit. I forgot. Okay. This is the coup de grace. Or there's so many coup de grace, and I just can't. You know, there's that chart, Ron, floating out there that shows like the number of words spoken by justices during oral arguments. It is, you've got like all women is by far the biggest number. And then Ketanji Brown Jackson by herself is in second place. And then it's all the men combined. Like, Ketanji Brown Jackson runs her yap during oral arguments more than all of the men on the Supreme
Justice
Court.
Thomas sat on the court for 20 years and said about 5 words before he started participating.
Clarence Thomas has said fewer words in 30 years on the Supreme Court than Ketanji Brown does in one oral argument. He just sits there and listens, and it's one of the most brilliant men that has ever lived. And it just goes to, oh God,
Example of this is something.
let's just drag it through the mud. Let's go, folks. Here it is.
A kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities.
Physical disabilities, right? They were in a wheelchair. They can't walk upstairs. You know, they can't. Okay. All right. Okay. Where are we going with this?
And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system.
Black people are the same thing as disabled people, according to Justice Ketanji Brown Jackson.
No, she might not be saying that. Not exactly saying that. What she's saying is something very much like that.
There's so much wrong with this. I don't even know where to start. This was like when I listened to this clip, I said, no, there's no way. Somebody AI'd this shit. There's no way. Oh no, it's real. It's real. I don't even know where to begin with this. Because somehow, you know, some kid with ALS in a wheelchair that can't walk, or with Parkinson's, or that has 2 broken knees or something, that can't walk upstairs or access or sit, you know, go to a public restroom the way that most of us can, you know, because there's not a bar there to grab or something to help them out of it. That is somehow the same as this case.
Well, okay, so I mean, look, what she's saying, it's preposterous, but what she's saying is black people are so, this is a ridiculous word that has become nonetheless a word, disadvantaged. It's like they are cripples. And let's say that, here's the point. Let's say she were right. Let's say she were right, and that's really were the case. There's no constitutional prohibition on treating handicapped people differently from the way you treat fully able people. But the Constitution does prohibit racial discrimination.
There you go.
So even if her analogy were appropriate, here we're dealing with something that this court has already said doesn't work. You can't use that as a rationale for treating otherwise similarly situated people differently.
The facilities have to be made equally open to people with disabilities if readily possible.
Not if readily possible.
I guess
that's not if readily possible. Mm-hmm. If reasonable, if accommodation can reasonably be made. You might say to me, Ron, that's the same thing as readily possible. No, it's not. It's a specific, those words, reasonable accommodations, are baked into the statute. You're a Supreme Court justice. You have to use the language of the statute. Come on, man.
Yeah, well, she uses her own stuff.
Understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system.
This is complete and utter bullshit. And let me go from the beginning of this. Let's go back to her choice of comparison here, which is the ADA, the Americans with Disabilities Act. Okay? And the ideas behind it. The ideas behind it was so that, as I mentioned earlier, somebody in a wheelchair could physically be able to access and have the opportunity to enjoy their pursuit of happiness at going to somebody's shop or store or this or whatever. Largely pretty innocuous stuff. Now, it did have some serious financial impacts on many businesses because, hey, they had to turn around and they had to spend money to install a wheelchair ramp or put the safety bars in the bathrooms or all this kind of stuff. But here's the thing, is that the people that would then enjoy these businesses that to that point heretofore they were unable to because of physical limitation, they were simply given the same opportunity as everybody else. There was no guarantee of results. There was no equity of outcome, right? Right?
Oh,
They still had to go.
Okay.
Well,
Can't you respond here that this is now the opportunity to elect? Like, they're not, even though in fact they're really giving these seats to these people, but there's still an election. You still have to win an election.
You still have to win an election, but the idea behind engineering these
but you
seats
will.
is to all is to all but guarantee a certain outcome, right? And that's the difference. This is why this comparison to the ACA doesn't work. You know what? And this is my point. There is no disadvantage to blacks or Hispanics or anybody else. If you are here legally, you are a citizen, and if you have decided to take it upon yourself to do your duty as a lawful citizen of the United States and go ahead and get yourself and maintain your registration to vote, you have the equal access, every man, every woman, white, black, Hispanic, Asian, otherwise, who was legally registered to vote has the exact same opportunity to cast their ballot as anybody else. And we now, in today's society, especially since 2020, we've gone overboard, in my opinion, making it so ridiculously retardedly easy to cast a ballot. There is no disadvantage to black folks to cast a ballot. They have the exact same opportunity as everybody else.
Oh, not so fast. I think you seem to have forgotten. Black folk don't even know how to find a picture ID.
Oh, I forgot.
That's a big disadvantage, okay?
The incredibly racist issue of having to provide a photographic ID, a legitimate, in many cases, state-issued photo ID, prove who you are so that they can match you to a voter registration so that you can be verified to vote once, provided, of course, you're still alive. But yes, I mean, this is the point. The whole idea, and this is what Ketanji Brown Jackson is kind of dancing herself into here, is that, and this is why this comparison is so bad, not just from the hilarity of it, that she's literally just compared blacks voting to basically people in wheelchairs having to have a special act to give them access. The problem is the comparison from that perspective, from the logical perspective, is just ridiculous because there is no issue with access. It's like saying, well, we would have passed the Americans with Disabilities Act to guarantee that they get the same outcome as people who don't have disabilities, right? No, they can still have access. We're going to make sure that they can get into a building. We're going to make sure that they have access to, physical access to get into a school or a business. But once they get there, that doesn't guarantee that they're going to score the highest grades or they're going to be able to participate on the regular boys basketball team from a wheelchair or something like that. Again,
right.
It's the engineering, the constant Democrat refrain that they want to and have to try to engineer not equal opportunity, but try to engineer the same outcomes for everybody. This is where the equity portion of DEI comes into play. And this is why it's always such a mess, is that you cannot engineer the same outcome for everybody, but you can give everybody the same opportunity. That's the basis, as far as I've always known it here in America. right, is everybody has equal opportunity, okay? Everybody's vote counts just the same. My vote counts the same as Ron's, the same as Ketanji Brown Jackson's vote when she goes into the polls, or at least it's supposed to. So, again, I find this argument to be really, really silly from that perspective. But she had a few more fun ones out there. Now, this was another piece here, and this is from Eric Daughtry, who's from Florida. DEI Supreme Court Justice Ketanji Brown Jackson is losing it because she knows the race-based VRA congressional districts are about to be abolished. She is yelling at the council and is clueless as to how the VRA process even works in Louisiana. So I'm going to play the clip here. And again, this is back to Benjamin Aguinaga. I'm good with French, but not Spanish. Benjamin Aguinaga, who is the Solicitor General here from the state of Louisiana, arguing in favor of abolishing these race-based districts.
I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying
in discrimination.
Right, exactly. And that's thank you for bringing that up, Ron. I was going to say, just a point of clarification, what she's talking about is, does the state have an interest in, and the subtext is race-based congressional districting? And Benjamin Aguinaga, Solicitor General for Louisiana, is saying, no, there's no interest in the state to have race-based congressional districts. And Jackson is saying, well, the obvious answer is actually yes.
I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
No.
Yeah, I know. Wait. Did you hear what she said there, Ron?
Right.
Did you hear?
Yeah, exactly.
You hear her answer to that? It's like, wait, the plaintiffs came in and they said, we deserve.
Let's start with the rationale and work our way backward.
Right, exactly. Y'all listen to this in the audience again, right? Well, the plaintiffs came in and they said, we want, or we deserve, under this law, another black congressional district in Louisiana. Okay?
Too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
We're mincing words here because apparently it's the same thing that Benjamin Aguinaga is saying the plaintiffs are claiming. They're saying they said they came in and they said, we want a second congressional district. And Ketanji's like, no, I thought they came in and they said, we're not being represented enough because our votes are being diluted. Ergo, they want a second fucking congressional district, Ketanji.
It's really something.
Oh, Lord.
Which is the same way of saying we deserve a second
No, it's
majority black
not,
district.
because again.
He even says it. I forgot about it. He actually does respond to her saying, we're saying the same thing, Your Honor. And then she immediately retorts with, no, it isn't.
No. It's not. This is really important. It's not the same thing. We're really talking about how it really went down.
Mm-hmm.
In other words, she, in her mythology, the mythology is, it's really just kind of works out that blacks get a second district. The real problem here is that blacks were deprived of electoral opportunities. And what he's saying is, empirically speaking, the politics of what happened in the Louisiana House was, or the Louisiana legislature was, it's time for another black district. That's actually how it happened. Yep. That's how I'm hearing it.
Okay. Fair enough.
votes are being diluted.
Which is the same way of saying
me back it up a
we
little bit
want
so we hear
another Robinson litigation. Certainly step 0 in the Robinson litigation is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No, it's
majority black
not,
district.
because again, just trust me on this, the second electoral
Trust me, bro.
or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Okay. Ron, thoughts there?
Well, I mean, I think it's just she's doubling down. She knows how it happened. It happened in the Never Never Land of, darn, it's funny how it works out. We're trying to figure out why there isn't a second black district here, and we thought it was because you might have thought it was because we count the number of votes, and the person who wins the most votes gets to. But no, it's not. It's not that at all. Electoral deny opportunity thing.
Yeah.
And he's saying, no, actually, that's not how it happened here. Okay.
Well, and she goes in the end and she starts saying how, if there's an issue or not, and deciding whether or not there's an issue and if the remedy is going to be to add a second congressional black district. And what my layperson's read when I hear her, again, we already know she's made up her mind. We already know which way she's voting on this issue. We don't even have to question it. But the idea is that, as a justice, it seems like she's already starting from the standpoint of there's nothing wrong with the law, the statute in this case.
Absolutely. That's right. 100%.
That's totally fine, right? She's already moved on to whether or not the statute that in her mind is right dictates that there be another district in Louisiana. Versus,
that's just a funny, a wacky coincidence.
It's a very wacky coincidence. As opposed to what Benjamin Aguinawa is trying to argue here on behalf of the state of Louisiana as Solicitor General is to say that, no, Your Honor, your premise to begin with is wrong. The underlying statute runs afoul of the Constitution, and there shouldn't be any engineered white districts, black districts, Hispanic districts.
So
period.
So you're against handicapped people, aren't you?
Yes. Of course, because that's what you have to be, right? Oh,
pretty much.
God.
That's how it comes out.
You don't want kids to eat school lunches where you want kids to starve. Remember that one, Ron? Remember that one?
Exactly. It's
the federal school lunch. It's the same thing.
Game.
You want children to starve. You want to push old people off a cliff, Ron. Remember they made a TV commercial with that one?
In their wheelchair, yes.
In the wheelchair, yeah. It was George Bush, wasn't it? Pushing the old person off the side of a cliff in a wheelchair.
Good
Democrats.
times.
It's like, good Lord. I miss those days compared to with the crazy shit that we have today. Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.